நாகவிகாரை யாழ் நகரில் ஆரியகுளம் சந்தியில் அமைந்துள்ள இவ்விகாரை வடக்கில் பிரபல்யமான பௌத்த விகாரையாக காணப்படுகின்றது. தென்னிலங்கையிலிருந்து வரும் சுற்றுலா பயணிகள் அதிகம் செல்லும் விகாரையாகவும் இது அமைந்துள்ளது. யாழ்ப்பாணம் பெரிய பள்ளிவாசல் 1713ஆம் ஆண்டு கட்டப்பட்ட இப்பள்ளிவாசல் யாழ்ப்பாணத்தில் உள்ள மிக பழமை வாய்ந்த பள்ளிவாசலாக காணப்படுகின்றது. யாழ்ப்பாண நகரில் இருந்து 2 கிலோமீட்டர் தொலைவில் நாவல் வீதி கண்மையில் இப்பள்ளிவாசல் அமைந்துள்ளது. மாவட்டபுரம் கந்தசுவாமி கோவில் 8ஆம் நூற்றாண்டில் வாழ்ந்த சோழ நாட்டின் இளவரசி இங்கு வந்து முருகக் கடவுளை வழிபட்டு கீரிமலையில் நீராடிய போது குதிரைமுகன் நீங்கியது. இதனாலேயே இக்கிராமத்திற்கு மாவட்டபுரம் என பெயர் வந்ததாக சொல்லப்படுகின்றது. சங்கமித்தா விகாரை சங்கமித்து என்ற புத்த பிக்குணி வெள்ளரச மரக்கன்றினை இலங்கைக்கு கொண்டுவர அதனை தேவநம்பியதீசன் என்ற அரசன் பெற்றுக் கொண்டதாக சொல்லப்படும் ஜம்புகோளப்பட்டினத்தில் இவ்விகாரை அமைக்கப்பட்டுள்ளது. செல்வச்சந்நிதி முருகன் ஆலயம் யாழ் நகரில் இருந்து 22 கிலோமீட்டர் தொலைவில் இம்முருகன் ஆலயம் அமைந்துள்ளது. இங்கு பூஜை செய்பவர்கள் ஏனைய ஆலயங்களில் பூஜை செய்பவர்கள் போலல்லாமல் தமது வாயினை வெள்ளை துணியினால் கட்டியவாறு பூஜை செய்யும் கப்போராளிகளாவர். வல்லிபுர ஆழ்வார் கோவில் 13ஆம் நூற்றாண்டில் கட்டப்பட்ட இக்கோவில் அமைக்கப்பட்ட காலம் தமிழ் பௌத்தர்களும் இந்துக்களும் ஒன்றாக வாழ்ந்த காலமாகும். இவ்வாலயத்தின் மூலஸ்தானத்தில் சங்கு சக்கரம் வைத்து வழிபாடு மேற்கொள்ளப்படுகின்றது. பருத்தித்துறை நகரில் இருந்து கிழக்காக 6 கிலோமீட்டர் தொலைவில் இக்கோவில் அமைந்துள்ளது. நைனை நாகபூஷணியம்மன் ஆலயம் வடமாகாணத்தின் நாகர் வழிபாட்டின் கோவிலாக காணப்படும் இக்கோவில் 64 சக்தி பீடங்களில் ஒன்றாகவும் கருதப்படுகின்றது. ராமாயணத்தில் ராவணன் சக்தி வழிபாடு செய்த தலமாகவும் இது கருதப்படுகின்றது. நாகதீப விகாரை இயக்கர் நாகர் என்னும் இரு பிரிவுகளுக்கிடையே ஏற்பட்ட அரியணை பிணக்கை தீர்ப்பதற்கு நைனாதீவுக்கு வந்த புத்தர் அப்பிரச்சனையை சுமூகமாக தீர்க்க அவ்வரசர்கள் தமது அரியணையை புத்தருக்கு பரிசளித்தனர் என்ற வரலாறோடு தொடர்படும் இந்த நாகதீப விகாரைக்கு அதிகளவான பௌத்தர்கள் வருவது வழக்கமாகும். முருகண்டி பிள்ளையார் கோவில் யாழ் கண்டி வீதியில் முருகண்டி பிரதேசத்தில் அமைந்துள்ள கோவிலே இதுவாகும். பிரதான வீதியூடாக பயணம் செய்பவர்கள் தரித்து நின்று இளைப்பாரி செல்லும் இடமாகவும் இக்கோவில் காணப்படுகின்றது. பார்ப்பதற்கு சிறிய தோற்றத்துடன் காணப்படும் இக்கோவில் பிரித்தானியர் காலத்தில் கட்டப்பட்ட மிக நீண்ட வரலாற்றை கொண்ட ஆலயமாகும். புளியம்பொக்கணை நாகதம்பிரான் ஆலயம் மிக பழமை வாய்ந்த நாகர் வழிபாட்டு தலமான இங்கு பக்தர்கள் வெள்ளை நாகத்தை வழிபாடு செய்கின்றனர். அத்தோடு இங்கு வாழும் மக்கள் நாகத்துக்கு தீங்கு விளைவிக்க மாட்டார்கள் என்றும் நம்பப்படுகின்றது. வெற்றாப்பளை கண்ணகியம்மன் ஆலயம் முல்லைத்தீவு நகரில் இருந்து 3 கிலோமீட்டர் தொலைவில் அமைந்துள்ள இக்கோவில் தமிழ்நாட்டில் கண்ணகியம்மனுக்கு கோவில்கள் அமைந்த அதே கால பகுதியில் தோற்றம் பெற்றது. ஒட்டுசுட்டான் தான்தோன்றீஸ்வரம் முல்லைத்தீவு மாவட்டத்தில் ஒட்டுசுட்டான் பிரதேசத்திற்கு அண்மையில் அமைந்துள்ள மிக பிரபலமான சிவாலயம் இதுவாகும். இங்குள்ள சிவலிங்கம் தானாகவே தோன்றியதாகும். மடுமாதா தேவாலயம் கத்தோலிக்கர்களின் புனித தலமாக காணப்படும் இத்தலம் மூவின மக்களும் வழிபாடுகளில் ஈடுபடும் யாத்திரிக தலமாகவும் காணப்படுகின்றது. மன்னார் மாவட்டத்தில் எழில்மிகு காடுகளுக்கு நடுவில் அமைந்துள்ள 400 ஆண்டுகள் பழமை வாய்ந்த தேவாலயத்தில் ஜூலை மாதம் 2ஆம் தேதி தொடக்கம் ஆகஸ்ட் 15 வரை இங்கு திருவிழா சிறப்பாக நடைபெறும். திருக்கேதீஸ்வரம் மன்னார் மாவட்டத்தில் அமைந்துள்ள இவ்வாலயம் இலங்கையில் உள்ள பழமை வாய்ந்த 5 சிவாலயங்களில் ஒன்றாகவும் தேவார பாடல் பெற்ற தலமாகவும் காணப்படுகின்றது. 2000 ஆண்டுகளுக்கு முற்பட்ட கால வரலாற்றை கொண்டமைந்த இக்கோவில் 1570ஆம் ஆண்டு போர்த்துகேயரால் உடைக்கப்பட்டு ஒல்லாந்தர் காலத்தில் மீண்டும் கட்டப்பட்டது. மடுக்கந்த விகாரை மகிந்த தேரர் வெள்ளரசு மரக்கிளையை இங்கு வைத்து பூஜித்ததாகவும் 4ஆம் நூற்றாண்டில் புத்தரின் தந்தம் இவ்விகாரை அமைந்துள்ள இடத்தின் ஊடாக அனுராதபுரம் கொண்டு செல்லப்பட்டதாக வரலாறுகள் கூறுகின்றன. கல்வாரி தேவாலயம் வவுனியா மாவட்டம் வவுனியா நகரில் இருந்து 10 கிலோமீட்டர் தொலைவில் பெரிய கோமரசங்குளம் பகுதியில் உள்ள மலைக்குன்றில் இத்தேவாலயம் அமைந்துள்ளது. இயேசுபிரானின் பல்வேறுபட்ட திருப்பாடுகளை சித்தரிக்கும் சிற்பங்கள் இம்மலை உச்சியில் காணப்படுகின்றன. பழனிமலை முருகன் கோவில் வவுனியா மாவட்டம் சிதம்பரபுரம் கிராமத்தில் 200 மீட்டர் உயரமான மலை உச்சியில் அமைந்துள்ளதே இவ்வாலயமாகும். வடக்கில் காணப்படும் ஒரே ஒரு மலைக்கோவிலான இதற்கு செல்வதற்கு 400 படிக்கட்டுகளை கடந்து செல்ல வேண்டும். நெடுங்கேணி வெடுக்குநாரி மலை மலைக்குன்றுகள், மலைச்சாரல்கள், குகைகள் நிறைந்த இப்பிரதேசம் இலங்கையின் ஆதிக்குடிகள் வாழ்ந்த பிரதேசமாக அடையாளப்படுத்தப்பட்டுள்ளது. வவுனியா மாவட்டம் வவுனியா வடக்கு பிரதேசத்தில் இம்மலை அமைந்துள்ளது.
Hello, welcome everyone. Aibowan and Vanakkam. I am a moderator for today's event. I am joining from Ottawa. Today, we are going to discuss how that resolution passed at the United Nations Human Rights Council is going to affect for Sri Lanka. Aftermath of our topic is aftermath of UNHRC Resolution and what is next. Then also we will discuss had LTT lost its political game in the UN system. So then I will do my little preamble about this today webinar. And I am a adjunct professor and research fellow at the International Center for Interdisciplinary Research in Law, Laurentian University, Canada. Then today we have 3 distinguished panelists. Amara Kunanayakam from Sri Lanka. She is a former ambassador and permanent representative of Sri Lanka to the UN at Geneva. She has vast experience about this UN system, and she will bring much more information to the best interest for all the participants. Second panelist we have it today, Professor Dr. Mehmet Sukri Gazel from Switzerland. So he is joining with us live from there. He is a director, Center for Peace and Reconciliation Studies. Then our third panelist, Mr. Jayaraj Paliyavarna joining from United Kingdom. He is a convener, London Initiative, and he is a solicitor and attorney at law. So then, welcome all again. Once we start the campaign, and we have done tremendous work about the subject. We know that UNHRC resolution against Sri Lanka adopted 22 to 11, and 14 abstain. And when we compare to our campaign, we had a two-pronged approach. One is the reduced tone of the resolution. If we cannot come to the consensus solution, if not, reject the resolution. Then, as a result of this campaign, and we were able to we prevented ICC recommendation, prevented International Independent Investigation Mechanism, they call IIM mechanism, and prevented crime against humanity and war crime recommendation, and prevented referendum based on succession theory, and pro-LTT Tamil terrorist sympathizers campaign against Sri Lanka successfully mitigated and countered. Now, we had one very important question. Should Sri Lanka accept the resolution? If not, then we are not going to call for a vote. We knew at the beginning, it is a difficult task to win since NATO alliance, 30 countries and EU bloc support the resolution. For this resolution, 30 countries, there's NATO alliance, and they co-sponsored or supported resolution, except Hungary and Turkey. So this is the geopolitical game in the Pacific region. So that is our opinion. So now, format of this webinar will be, I will post when opening statement to each and every panelist, and they will introduce you their idea about how is going to affect for resolution for Sri Lanka. Then I will post questions and answers to each and everyone. We have received over 500 questions, but I'm not going to mention each and every individual who said their name and the location. We consolidated all the questions because some of the questions are very similar to each other. Therefore, we consolidated the question, and I will post this question to the panel. Then I will ask their opinion. So, before we start this, the question. So there's one question came, very important question. So this question will ask all three panelists one by one. First will go to Tamara, and second will go to the Professor Gazelle. Then third one will be the Jara. Resolution AHRC 46/L Rev 1 dated 16th March 2021 has been adopted by UN Human Rights Council based on procedures and practices adopted by Committee of General Assembly. Of the 47 members in the Council, 22nd member state cast affirmative vote, 11 members opposed it, and 14 abstained. The procedure adopted does not recognize number of votes that abstain. Therefore, adoption of resolution was based on 22nd affirmative votes, which is less than the half of 47 members in the Council. In other words, Council for adopting a procedure that permit a resolution to be adopted when more than half of its members decided to not to support it for whatever reason. Can you please explain, Tamara? Should this outcome can be caused to fault for this resolution, or otherwise we can nullify this resolution based on this outcome?
Thank you, Neville. I'll try to explain that it's a very complicated and long question to answer. So bear with me, because I think it's important that we all understand what we are talking about, because the implications that the resolution can have or has, or the impact, depends on other surrounding questions. So I would like to explain to you, first of all, you raised the question of the vote. In my view, the the issue of the number of abstentions, number of voting for and against is not important. What is important is that it was not a consensus resolution, because a consensus resolution would mean that Sri Lanka would have accepted all the underlying logic in the report, or the Bachelet report, which was then reproduced in the text of the draft resolution, that would have undermined Sri Lanka's sovereignty, and at the same time, it would have prevented Sri Lanka in the future continuing to resist external intervention and domination. So the fact that it called for a vote means that it does not accept the content of the resolution, and it permitted friendly countries, its natural allies, also to take a public position. So they may have abstained or they may have opposed it, but it comes to the same thing, because it's not a consensus. It means that they do not agree with the underlying logic. It allows future space for them to continue the battle. So let me first of all explain. You raised the question of this voting, whether it is unfair. The Human Rights Council adopts a voting procedure that is in accordance with the UN Charter, which is Article 18 of the Charter, says very clearly that the resolutions will be adopted by a majority of members present and voting, except in the cases of important questions that are linked to international peace, maintenance of international peace and security, membership, expulsion, and new members coming in, as well as the budget. So we could, and then you would require two-thirds majority. So this, it was not, perhaps Sri Lanka could have, through friends, because we are not members of the council, could have raised the issue of this is not, this is an important matter and therefore should have been voted two-thirds. It would have been a procedural motion that would have had to be then adopted as a resolution. We didn't do that, but it is done systematically. A number of states do it in the General Assembly. So we still, the fact that we didn't, we rejected it, and the fact it's not consensus allows us to continue that battle in the General Assembly, but also in the next sessions of the Council. So that is the one on the question of the vote. The second point that I want to make is, because if you want to interpret the outcome of the vote, we have to first of all understand what the Human Rights Council is about, and what those decisions really mean. The Human Rights Council has to also function within the framework of the Charter. All human rights issues, the UN can only handle human rights issues through cooperation with member states. So that is a fundamental, and that's the Chapter 10 of the UN Charter, which requires cooperation. You cannot impose on a state promotion and protection of human rights. That's how the Charter functions, because of the fundamental principle of sovereign equality of states. So other states cannot impose. They are internal issues, and the state has the primary responsibility to protect its citizens. And internationally, states have an obligation to cooperate with that state to help that state to fulfill its obligations. Now, what has happened in the Human Rights Council is that since the collapse of the socialist bloc and the emergence of a unipolar world, with the US in a position of global hegemony, it has converted the Human Rights Council into something else. They have tried to use human rights as a weapon to achieve a number of objectives. One of them is to replace, because that's what's going on in the Human Rights Council. It's a struggle between two visions of what the international order should be. One is based on the UN Charter, which is based on multilateralism, that is sovereign equality of states. The other is the vision of the United States, which is a global order based on its leadership and on the rules that it determines itself. So that's the battle that's going on in the Human Rights Council, and everything that is taken up, all the issues that are taken up, are not on human rights. That's why we refer to double standards in the Human Rights Council. It's based on achieving those objectives. The second objective is it wants to instrumentalize the Human Rights Council and the UN Secretariat in order to achieve its objectives. So under the Charter, the Human Rights Council and the General Assembly do not have legislative power. They are only their resolutions have only a status of recommendations. They're not binding. They're not binding, except in the case of the Security Council, and even that only under Chapter 7, which is if there's a threat to international peace and security or if there's an act of aggression. But human rights does not come under that. But they would like to instrumentalize, and that's what they've been doing. Thirdly, they use human rights as a means to exercise pressure on other states, to states that either resist US leadership globally or who either refuse or hesitate to join Washington's global objective. Currently, it is to assemble a global coalition of forces to combat China. That is a very clearly stated strategy of the United States right now, and it is to change the system in China. And if you look at the Atlantic Council paper or the Biden administration's policies right now, is to not just to combat the counter the trade competition, but actually intervene in the internal affairs of the Communist Party itself and change the nature of the state. So this is what they are about now. So so the point is that the resolutions that are adopted by the Council are not technical. So we cannot look at it as something technical and about human rights, but they are political statement. And they reflect the balance of forces at a particular time in history, in the historical moment. But this is not a static moment. Globe is changing, things are changing. US hegemony is under challenge. United States and the Western countries are in a major economic crisis. The Chinese example under COVID has become a model for even people within the Western countries. So there are a lot of changes, and so we have to look at the resolution in that context. The resolution itself on Sri Lanka has also several objectives, which I've already pointed out to some of them. That is, it seeks to validate the report, the Bachelet report, is based on a logic. The underlying logic of the report is the responsibility to protect, which, and that's stated in paragraph 56 of the report, says very clearly that Sri Lankan government is unwilling and unable to protect its citizens. That is the crux of the R2P. So the third pillar of R2P, which is in violation of the Charter, says if the state cannot fulfill its responsibility, which is a responsibility under the Charter, and if it does not accept international cooperation, then, or if it's a failed state, then we should, international community should be able to intervene and decide, take over from the state its right. So it deprives the country of its sovereignty, its right to self-determination and its sovereignty, and literally takes over the running of the country and dominates. It's a recolonization that takes place. Now, this Bachelet report has concepts in it which were then taken over and incorporated into the resolution by the sponsors, because I worked within the Office of the High Commissioner for 10 years. So I know exactly who writes the reports. The reports are written by those who want to then continue to have taken initiative inside in the council, and has functioned as a kind of catalyst. So the United States has used the Office of the High Commissioner as a catalyst to present then resolutions that it seeks to exercise pressure and to create this new rule that they want, a new order which is based on US objectives and not the UN Charter. Sovereignty is the main obstacle to US hegemony, and so they have to undermine it. This report has all the elements of the undermining of sovereignty. So you have R2P in it, you have the validation of, if adopted by consensus, by the way, we would have validated unilateral coercive measures, sanctions, and we would also validate the expanding the scope of universal jurisdiction to include human rights. Now, that is not accepted by the states. It's been opposed by a majority. Universal jurisdiction is used in the case of piracy, for example, in the case of the high seas, extraterritorial seas. But you cannot use it, you cannot impose it, you cannot judge a person in the country, in another country, for something that has happened in the third country. And where that country where it's taken universal jurisdiction is practiced has nothing to do with either the act or the citizenship of the person. That's totally unrelated to what has happened. So, and then it also gives a prosecutorial function to both the Human Rights Council and to the Office of the High Commissioner. So you have the paragraph you refer to in the resolution, which allows the Office of the High Commissioner to collect and preserve, analyze information and evidence to be used. But that's what's important about the resolution. Not only that it has a prosecutorial function, but it's going to give it to countries that practice universal jurisdiction, which are primarily Western states, parts of Latin America, and of course Malawi, which is a key strategic ally of the United States in Africa. So you have the universal jurisdiction of those states. So what they will do is the UN, this resolution will go to the General Assembly for budget approval, and the budget, the regular budget, involves the contribution of all states, including Sri Lanka. So they will use the budget, our money, to fight cases against our people in a foreign court, in a national court somewhere outside in the West. You can say it's the West, or in its courts of its allies, and we will be paying for the prosecutorial work against our own people. So this is. That is on the UN side. Then the resolution also seeks simultaneously, because that's also what the resolution is about, is to put pressure on Sri Lanka here within Sri Lanka to bring it within the ambit of the quadrilateral, which is the military, the alliance that it has set up in the so-called Indo-Pacific region, with India, Australia, Japan, and the US involved, and which is the objective of which is to combat China. And the other objective is they would like to bring Sri Lanka within this global coalition that the current administration, including, is assembling. So you have the discussions we've had in Sri Lanka, MCC so far, AXA discussions, which the people are opposed to. So those they want to use pressure on the government to do that. So now to return to the question of how to interpret the outcome, is first of all, it is a failure. It shows the failure of the West to impose a consensual resolution, because that's what they wanted. The moment that it's a consensus, we cannot fight it anymore, because it means we have accepted and validated all those principles, and we would have lost our allies in the non-aligned movement. Secondly, it's a political failure for all those within, inside and outside Sri Lanka who were ready to compromise on the sovereignty by negotiating with those who have the unilateral vision of the world, those that are hostile to Sri Lanka. So negotiating, we inside Sri Lanka, we opposed all negotiations on the language, because the issue of the resolution is not words, 1, 2 words, or one paragraph here or there. It's the whole logic that the resolution implies. So you had to reject that logic, because otherwise we would have accepted 30/1, we would have accepted Bachelor report, and we would have tied our hands for future. And so that is the other thing. The other third point is that it means that Sri Lanka and those who opposed or even abstained have now have the space to continue to resist foreign domination. So they can because as you know, the resolutions reflect the global balance of forces, which are not static, so they keep changing. So we can in the future we can change that resolution. So you come to that question of whether we can do anything to you refer to nullifying it. I wouldn't use the word nullifying, because that's the legal term, which means you recognize that this document is a legal document. It's not a legal document. It's a recommendation simply. So it can raise the issue in future sessions, both in we'll come to that later, both in the General Assembly and in the Human Rights Council itself. And I think much more importantly, it also means that Sri Lanka itself, there was a hesitation about calling for a vote. So the call for a vote had to do with pressures within Sri Lanka on the government to reject the resolution, not just by saying we reject it, but actually getting a friendly state to call for a vote, because otherwise we would have had a resolution to which we agreed, and we would have tied our hands. So I think it's a good, we are in a good position.
Yes. Thank you very much, Samara. And so it is a great introduction, and then how UNHRC function and UN mechanism function. So now I am posing the same question to Professor Muhammad and Ghazali.
Many thanks, Dr. Neville. After the speech of Ms. Tamara, it's a wonderful speech. I don't want to repeat the same things, but the important point is, as she mentioned, paragraph 56 of the Bachelet's report and the responsibility to protect. And from the beginning, in fact, they tried to prove that Sri Lanka is a failed state. I would like to return what we had lived in the past inside the UN human rights sessions and during the site events, but we have listened. I mean, I got that trace inside the UN from the LTT members. So the important point is that everybody knows that Human Rights Council is a political body like the General Assembly and Human Rights UN General Assembly and Security Council. But the UN Office of High Commissioner must be neutral and must respect to its work. What we had seen is in the past to prove that Sri Lanka is a failed state, so that they can interrupt the responsibility to protect. In the resolution 25/1, which demanded to organize a committee of inquiry for Sri Lanka, it defined the past armed conflict in Sri Lanka as combats terrorism, which made automatically LTT as a terrorist organization. But when Office of High Commissioner prepared their report, or OCLE report namely, they defined the past armed conflict from combat terrorism to a civil war. And they defined LTT from a terrorist organization, redefined from a terrorist organization to a non-state armed group. This is the important case. And as an obligation, they have to implement the global counterterrorism strategy. Still, the UN Office of High Commissioner never implement the UN global counterterrorism strategy, even it is an obligation. There is an important point. Why? In the resolution 30/1, it asked a committee of inquiry, but within a juridical mechanism inside the Sri Lanka, but they defined it, especially the LTT members, as an international committee of inquiry, which was not. But they never asked to implement the UN global counterterrorism strategy. Here is the game, because the aim of the UN Human Rights Council, with its mandate, to prevent the reoccurrence. And with OSCE report and with the resolutions, they give a total impunity to LTT and the finance of terrorism in Sri Lanka. And this is against the logic of the UN Human Rights Council and its mandate to prevent the reoccurrence. And it creates another thing. It creates as if LTT is a national liberation movement who has got a remedial suggestion when they try to implement with the report of Bachelet's report in paragraph 56. So in my opinion, the voting is something, and the legitimacy and legality of the Office of High Commissioner is something other. And let me tell you, during the human rights sessions, we organized site events on implementing UN Global Counterterrorism Strategy for Sri Lanka. And we asked for an international committee of inquiry for the finance of terrorism with the next resolution, and also in the reports of Office of High Commissioner. It is totally neglected and never accepted. And let me tell you something. In the resolution 40/1, in the operative paragraph, it only asks the government of Sri Lanka to implement fully measures to identify by the council. But in the 30/1, they also ask to implement the accountability. And there is another game being played. This is, they only implement the international humanitarian law in Sri Lanka. When you implement the international humanitarian law, time and the geography is limited. But if you use UN Global Counterterrorism Strategy, time and the territory is not limited, and to fight against terrorism is all the world. But when the Office of High Commissioner refused this, it gives total impunity to terrorism, and it is a sabotage for the future peace process in Sri Lanka, that is the reconciliation, because they give a total impunity to terrorism. And the ex-cars of LTT is well and living. And according to the CIA fact sheet for Sri Lanka, they still collect money from international criminal business. And I would like to say something for the end. It is that now there's a technical game is being played, but all the other states, including the voter states positive for this resolution, do know very well exactly that there exists nothing as mentioned in the Baccalaureate report. It's a game of mercenary reporters, as I mentioned, inside the Human Rights Council. Thank you very much.
Thank you very much, Professor. So now I will pose the opening plenary question to Jayaraj Paliyavadana from United Kingdom. Floor is yours now.
Thank you, Neville. I'm not going to give you a comprehensive answer because I saw Samara gave a very good introduction as well as a good answer to that question. I think she covered all the areas, so I have I don't have anything to add apart from the fact that we all understand the pattern and the way that the member countries voted during the 46th session against Sri Lanka's in regards to the Sri Lanka's resolution, that it has shown that it is not about human rights anymore. The countries voted according to their geopolitical interests. So that is the fact. So that is the fact the Sri Lanka government and the international community should understand. It is not the human rights anymore. It is just the geopolitics played the role. So that is all I can add to that question, Neville.
Thank you very much, Jayaraj. So then, so we have as I told you, so we receive over 500 questions. So therefore, we consolidate the question. So therefore, I cannot tell the individual name and the country. But if you see that your question is answered, so if you have a follow-up question, you can email us so we can produce that question to the panelists. Actually, in addition to this previous question, so I have a follow-up question for you. Is it a sign of eroding trust and credibility of the UNHRC? So I will start from Jayaraj now.
Yeah, it is. I agree with you. I agree with the question. It is the eroding of the trust because it is eroding of the trust not just from the Sri Lankan side. It is eroding of the trust from the LTT side as well. I think most of the pro-LTT supporters has to accept. I saw some news article about the LTT supporters expressed their dissatisfaction over the resolution as well. So we all aware that the accountability through the international judicial mechanism has been the main agenda item of the LTT supported diaspora since the end of the war in 2009. So originally, the demand was for a full functioning international mechanism. In 2015, UNHRC had been lowered down this demand to hybrid code through the 30/1 resolution by upsetting some of the co-LTT supporters. That is the well-known fact. However, the resolution had many other conditions paving the way for international prosecution. It is important to note that the then government had some legislations enacted as recommended by the resolution, such as Office of Missing Persons, to please the international community to show Sri Lanka's positive steps toward the accountability. So now we have the resolution 46/1. It has been narrowed down the scope of the international investigation mechanism as originally demanded. So it is, I'm talking about from the side of the LTTE, it is not what they expected. So it is from both sides. I believe we have to accept that reality. The UNHRC mechanism is failed.
Thank you very much, Jayaraj. So then now to my question to Professor Gazel. That the question is it a sign of eroding trust and credibility of the UNHRC?
I mean, as Human Rights Council is a political body, it is the loss of prestige of the core group, I do believe. That is the United Kingdom and the others, because what they ask and demanded in 30/1 is different, and we have proved that they have to implement the UN Global Counterterrorism Strategy for transnational justice as well, in the victim-centered approach that they have to approach for the post-war armed conflict, but they refused to do it. Because if the core group, as an obligation, defined LTT as a terrorist, they have to ask to implement the UN Global Counterterrorism Strategy. I can mention that there's a lady in UK, and she's famous of recruiting child soldiers and giving seniors for the child soldiers. And she's living in United Kingdom. And United Kingdom, as a procedure for the in this resolution, can open a court for this lady, but they refuse to do it. So the roadmap of the United Kingdom, in fact, to define LTT as a non-state armed group based on a right to self-determination, because of a failed state and on discrimination. And the important part is that all the legal reports in the past, everybody knows that it has been, how can I say, programmed and fabricated. And the so-called genocide claims by the OECD report, maybe we can mention it later on. But in Article 5 of the last resolution, the universal jurisdiction and the demand for an international investigation is reasoned. And it is written that, notes that the persistent lack of accountability of domestic mechanism that the Domestic Commission of Inquiry announced on 22nd January 2021 lacks independence, and that its mandate is to review reports of previous commissions and committees, and does not include a mandate to pursue accountability for past gross violations of human rights or for its violations of international humanitarian law. I mean, this commission was made subject to Resolution 30/M, but it was not enough. What they asked is the Commission of Inquiry has lacks of independence, that is a mandate to review. And the concept of the core group is based on one thing, war crimes, but in which sense? There are two types of war crimes. First of all, we have to mention that there is no war without war crimes, unfortunately. But the definition of war crime subject to International Criminal Court Rome Statute, let me read it. I do not mention about the crime against humanity because there exists no on the part of Sri Lanka government. But Article 8 defines war crime subject to universal jurisdiction. This is important. It says that the court shall have jurisdiction in respect of war crimes, in particular when committed as a part of a plan or policy or as a part of a large-scale commission of such crimes. So, is there a planned war crimes by the Sri Lanka government? They have to prove this by false and fabricated reports so that they can ask for the implementation of responsibility of protect for Sri Lanka. And this is the main issue. What is known in my discussion with diplomats from abstain states and even the states who voted in favor of the core group, everybody knows that there is no war crimes in the sense of ICC Rome Statute, and everybody knows that the core group was defeated. And because of that, the UK or other European states ask for a resolution as a third state to use universal jurisdiction. If not, the UK can open a court to Sri Lanka government as of today. But everybody knows that there is no war crime in the sense of ICC Rome Statute Article 8. And the loss of credibility is not the Human Rights Council, but for the core group, especially for the United Kingdom.
Thank you very much, Professor. Then I will pose this follow-up question to Tamara. And the question is a sign of eroding trust and credibility of the UNHRC.
Thank you, Neville. I would agree with both the earlier speakers about that it was rather a loss of credibility for those who moved the resolution, the sponsors of the resolution, and the pro-separatist forces outside, because the objective was to establish, and this has been there from the beginning, that the objective of the separatist forces outside was to establish international so-called independent investigation mechanism, and that was in the form of a tribunal. So you had this the hybrid effort to come up with a hybrid tribunal, which was rejected inside Sri Lanka because it violated also our constitution, but because of the inability, because if you take, there are two options for set up an international investigation. Either you send Sri Lanka to the ICC, or you set up an ad hoc tribunal. Now, both these can only be done by the Security Council. It is not the mandate of the General Assembly, cannot do it, and nor can the Human Rights Council. But within the Security Council, they have a problem because they will have the veto of our friends there. It would be China and Russia would definitely veto that. Not only because they are friends with Sri Lanka, because they do not want to undermine the Charter or the Security Council, because the Charter is the organ, the Charter is if you like, the world constitution that enables countries to defend their sovereignty. It's a guarantor of state sovereignty. So they will not want the Charter to be undermined in any way. What happened, I mean, there is an issue that's going on right now on this particular thing, is in 2016, for a long time, of course, the US has been trying to send Syria to the ICC, and it has always been confronted by a veto in the Security Council. So what did the Americans do? They moved it down to the General Assembly level, and they had a resolution adopted to set up a so-called independent, impartial investigation mechanism with exactly the same language that you will find in the resolution on Sri Lanka at the Human Rights Council. Now, that was passed by in the General Assembly, and unfortunately, 2016, Sri Lanka abstained. It should have voted against that resolution. It abstained, and ever since, there has been in the budget, the fifth committee of the General Assembly, which deals with the budget, there has been a Russian draft resolution to prevent a budget from being passed, which is something that we'll have to do at the forthcoming General Assembly. Is if we block the budget, you cannot implement it because there'll be no money, unless of course they get money from voluntary funds, which is problematic because then you have the direct intervention of those who have a vested interest in this universal jurisdiction. So what did they do? Because they cannot go to the Security Council, and they know that they will be confronted with veto, the Human Rights Council, they call for implementation or application of universal jurisdiction within the member countries of the United Nations, which mean national jurisdiction primarily in the West, with the United Nations actually funding the gathering of evidence and the material that is needed, which is why they call for this. But the national jurisdiction, those separatist forces know very well, and so do the West, they know very well that this is a very difficult exercise because they have tried to do it in other cases, but they have not succeeded. And the use of, for instance, arrest warrant, for instance, using Interpol for arrest warrant is very complicated because I just wanted I picked it up today, is that the General Assembly of Interpol adopted a resolution in 2010 with regard to its involvement in cases of genocide, war crimes, and crimes against humanity. And in the resolution says that the Interpol can process requests only if the requests come from international tribunals, if it comes from established entities established by the UN Security Council, and thirdly, if it comes from individual member states, then it has to, if it, that is member states, and it concerns a national of another member country, another state, a third state, then that other member state has the opportunity to protest against the request within 30 days. And if it protests, Interpol cannot act. And that's one thing. But also, if you see in national jurisdiction, there's also a lot of pressure in the Western countries, as we saw in the case of Spain. Spain, by the way, even had the Spanish courts called for the arrest of the former Chinese president and also the premier for genocide in Tibet. But it was so controversial that the parliament, the Spanish parliament, adopted a decision to change the rules in Spain in order to prevent this from taking place. Because it's a problem of, it's a political issue. Because if you want to arrest another member state, then it becomes a diplomatic issue. So not many states do not want to apply national jurisdiction. So it's understandable that both the LTT forces or pro-LTT separatist forces outside the country, primarily those who are outside the country, and as well as the sponsors of the resolution who wanted to bring Sri Lanka to an international court, did not succeed. So it also reduces their ability to exercise pressure inside Sri Lanka, because it also means, as I said earlier on, that within Sri Lanka there's an opposition to it. So it will be difficult for them to impose a decision like signature of SOFA, which is the military agreement which will allow the US forces to come into Sri Lanka with their weapons, with their uniforms, and to use Sri Lanka as a aircraft carrier for their wars. So it is difficult. It's going to be difficult.
Thank you very much, Samara. And so now we are moving to the very important part, for the second part. And so this question, so now we understood what is the UN mechanism, and the resolution has been passed, what they can do, what they cannot do. Pretty much they can't do anything. So now you have a clear understanding. There are so many ways to protect Sri Lankan sovereignty and integrity. So then other important question I'm going to pose to all the panelists, and the operative paragraph 6. But operative paragraph 6 of the resolution, it says, and Sri Lanka, with the view to advancing accountability, and decided to strengthen in this regard capacity of the Office of the High Commissioner. This is very important, to collect, consolidate, analyze, and preserve the information and evidence, and to develop possible strategies for future accountability process for the gross violation of human rights or serious violation of international humanitarian law in Sri Lanka. So there's two different major problems coming here with this resolution, as you can see. Problem is here, this is giving the capacity of the commissioner going to strengthen to collect evidence. So my question is that, can commissioner elect evidence in the other country? They have on the prejudice already, and they said the gross violation and serious breaches of international humanitarian law. But so far as of today, no one has come to the conclusion Sri Lanka or either Sri Lanka military forces has violated as gross violate or maybe serious violation of the international humanitarian law. Okay, so my question is going to Jairaj, and can commissioner collect the evidence for the gross violation of so-called I would say so-called and human rights or serious breaches of international humanitarian law? So what are the problems she is going to face?
Yeah, I'm going to answer this question in a different angle. I think the question we should ask is what Sri Lankan government is going to, or how Sri Lankan government is going to respond to this resolution at all, especially the section 6, operating paragraph 6 of the resolution, how the Sri Lankan government is going to react in responding to the section operating paragraph 6 of the resolution. So operating paragraph 6 of the new resolution to establish an evidence gathering unit with the assistance of the Human Rights Council's commissioner. So the purpose of this evidence gathering process is to support prosecutions suggested by the High Commissioner in her report, calling member countries to prosecute individuals under the universal jurisdiction or to refer into ICC. So it is positive. The most important question is that how the Sri Lankan government is going to respond to this operating paragraph 6. It is positive that Sri Lanka would not be going to implement recommendation of the report of the resolution. No one with the sensible mind would expect a country to cooperate with an international evidence gathering exercise against their own country. So we believe the Sri Lankan government would take every precaution to defend, find avenues to block the process, and make changes in Sri Lanka's laws and the legal system to protect Sri Lanka's interests. There is no doubt that Sri Lanka would see this as a threat. So definitely the country is going to take every precaution to block these processes. My understanding is that mainly Sri Lanka would consider introducing once again legal protections for armed forces personnel and veterans serving during the conflict times. Protections like the one introduced by then President J.R. Jayawardena during the 80s. We used to call it the Armed Forces Liability Protection Act. We call it simply I can't remember the single name, but it is called just to protect armed forces as well as the government officials from the criminal prosecution. We can see similar legislation in the US. They have the Hague Invasion Act, aims to protect United States military personnel and other elected and appointed officials of the United States government against the criminal prosecution by International Criminal Court, ICC. Also, in the UK, legislation is at the last stage. The legislation is at the last stage, that is with the House of Lords in similar nature, to take legal actions for armed forces personnel and veterans serving in operation outside the United Kingdom. So UK's legislation is the Overseas Operation Bill, that is how they call it, introduced by the Johnny Mercer, Minister of Defence. This bill is intended to protect members of the armed forces from what the government believes to be the vexatious legal action. We know that such legislation would not validate across the border. In such legislation is passed, if passed, is only valid within its jurisdiction. However, it will give some basic ground for Sri Lanka to stand. In other words, not to cooperate with an international investigation. For Sri Lanka, there is an easy way of introducing this. Just ask the UK government to supply a copy of the recent UK Overseas Operations Bill and implement the similar one with the necessary amendment, of course, with the support of the UK government. If UK has to protect UK's armed personnel, why not Sri Lanka? That is the obvious question that Sri Lankan government can ask. So in addition to that, there are 4 legislations enacted in Sri Lanka as recommended by the Resolution 30/1 as agreed through the co-sponsorship. Irrespective of the way they named those legislations at the time, one can argue that those legislations are in a way to support international prosecutions as well. Now we can see that the threat for international investigations on its way with the support of UNHRC. Sri Lanka to do a comprehensive analysis how these legislations would support these international mechanisms. Their own legislations were passed during the Yapalana time in Sri Lanka. So the Sri Lankan government would abolish or make changes to these 4 important pieces of legislations in force, because if they exist, Sri Lanka has its obligation to support international prosecutions. Therefore, even we like it or not, from the Sri Lanka's point of view, these reversals be highly necessary to defend Sri Lanka's position. That is why I'm going to tell you now how these four legislations, the naming, Victim and Witness Protection Act, Office of Missing Persons Act, Convention Against Enforced Disappearances Act, and Mutual Assistance in Criminal Matters Act together lay the foundation for war crime prosecution, assistance in international prosecution against Sri Lankan armed forces. Those four pieces of legislations are very important, that because those legislation together, not one by one individually, together lays the foundation that to show the world that Sri Lanka is going to cooperate with the international prosecutions against its own country. So this is very important that if we get a time, I can go into one by one and explain how this legislation is going to affect if you get the time later on. So according to the Sri Lanka's perspective view, Sri Lanka hasn't said anything about this yet, but it is very important that Sri Lanka has to take a decision. Are we going to live with those legislation at the same time that the threat is hanging outside the Sri Lanka to prosecute Sri Lanka's armed personnel and the political leadership or the civil administration at that time? Are we living with these four legislations as well? So are we going to protect our armed forces, personnel as well as the administration or not? So Sri Lanka is going to decide in near future what Sri Lanka is going to do with these four legislations, as well as introducing or implementing something to protect Sri Lanka's interests.
Thank you very much, Jayaraj. So basically, you have highlighted today a very important fact on legislative mechanism. So what kind of action Sri Lanka should take? First, International Convention for the Protection of All Persons from Enforced Disappearance Act. Secondly, Office on Missing Person Establishment, Administration and Discharge of Function Act. Thirdly, Mutual Assistance in Criminal Matters Act. It is amended. Assistance and Protection of Victims of Crime and Witness, that is also that act has been amended. There is a 4 acts are collectively posing threat to Sri Lanka. So then second important the matter, so you have mentioned United States American Services Members Protection Act of 2002 and UK Overseas Operation Veterans Bills and so they are in the process of pass this legislation, and United States already passed, but UK it is in the process. So in that case, if we are going to repeal this all the 4 acts you have mentioned, and if we are going to put another legislation protect Sri Lankan armed forces from malicious prosecution from overseas influenced by the LTT diaspora, what are the obstacles Sri Lanka will face? So this is the follow-up question came from audience. What are the obstacles for doing it in Sri Lanka?
Yeah, to answer that question, I think we have to explain why these acts are going to threat the Sri Lanka sovereignty, or Sri Lanka is forced to cooperate on the international mechanism. I think it's going to be a little bit long answer. Is it okay if I explain one by one, not fully comprehensively, but with some kind of summary?
Yes, I think that's good. Yeah.
Yeah, the first one, I'm going to take the first one. The first one is the Mutual Assistance in Criminal Matters Amendment Act, number 24, 2018. So Sri Lanka has obliged under the Mutual Assistance in Criminal Matters Amendment Act to facilitate the criminal proceedings held overseas. So that is what we're having at the moment. That is the state we are having at the moment. The Act has provisions to facilitate overseas criminal proceedings. How? That is the first question. How they're going to assist or facilitate overseas criminal proceedings. Section 2(1)(a) of this Act says, to whom this Act applies. This applies to every country that is a part to an international or an organized or regional convention or other agreement which is in the interest of mutual assistance in criminal matter to which Sri Lanka has become a party, where before or after the date of the commencement of this Act. it is very important that before and after the commencement of this act, we are obliged to answer any country or cooperate with any country. The international standards has been recognized. So Section 3 of the Act lists out the nature of assistance that should be provided. This includes information regarding the location of witnesses and suspects, serving documents, interviewing and examining witnesses and suspects, and providing documents and articles. Section 4 and 5 of the Act stipulates the responsibilities of the central authority under this Act, which is to provide such assistance when requested by a foreign state, authority, or organization. The way the Act has been amended now, not only states, but also NGOs like International Truth and Justice Organization, Human Rights Watch can request the information gathering by the Office of Missing Persons. For example, if any country starts legal proceedings against Sri Lanka and Sri Lankan individual, whether it is Malawi or any other country, UK or any other country, we are legally obliged to supply and provide mutual assistance as required by our own laws. Accordingly, now the system and the legal framework are in place to extradite the alleged offenders to a foreign jurisdiction under the Enforced Disappearance Act, the one I'm going to talk about later, provide documentary and evidentiary support via mutual assistance in criminal matters. Reading this piece of legislation is in isolation convinces us that they are for the protection of promotion of human rights. However, the depth and the gravity of repercussions on the political sovereignty cannot be seen until and unless all four legislations are read together in the context of geopolitical interest in the Indian Ocean. The second one is the Office of Missing Persons Establishment, Administration, and Discharge of Functions Act 14 of 2016. The Office of Missing Person Act, which is said to be a non-judicial process, provides to gather information on abduction and unlawful detention. Section 12 of the Office of Missing Persons Act provides that the office can conduct an investigation and accept evidence regardless of the standard of proof required for civil or criminal proceedings under the evidence ordinance. The most important part is this: the evidence so-called can be used in proceedings before an international tribunal or tribunal in a country that is a party to the International Convention for the Protection of All Persons from Enforced Disappearances. Eventually, the information gathered by the OMP will be the focal of the prosecutor's claim against the members of the armed forces. So the third one is the International Convention for the Protection of All Persons from Enforced Disappearances Act, number 5 of 2018. So Sri Lanka became a signatory to the International Convention for the Protection of All Persons from Disappearances on the 10th of December 2015, and later ratified the same on the 25th of May 2016. The convention requires states to extradite offenders of enforced disappearances to a country where the case is heard, or surrender the offenders to an international tribunal whose jurisdiction that country recognizes. The offender does not need to be a citizen of that country. So Article 9.2 extends to any person who is present in the country, in that country, is a signatory to the convention. The wording, alleged offender is present, that wording threatens the traveling and employment of ex-officers of Sri Lankan armed forces. We have seen the effect of this act when in South American country, that such action has been already taken, about to take, but it was failed because the person knew it before it comes through, then he left the country. Accordingly, a person who is alleged enforced disappearance can be extradited to a country from Sri Lanka. In case where the alleged offender is present in a country, that signatory to the convention can be prosecuted against the offender or surrender him to an international criminal tribunal whose jurisdiction that country has recognized. Accordingly, Sri Lanka as a country that is a signatory under the International Convention for the Protection of All Persons from Enforced Disappearances Act of 2018, now obliged to extradite the alleged offender to a country where a criminal action is constituted for the enforced disappearances. So enforced disappearance is a crime accepted as a crime against humanity. So it's one of the principles that are accepted by the legal arena in international world. So as per Section 10, at the time this act come into operation, is there any extradition agreement between the convention country under the extradition law 1977? Those agreements deemed to be established under this act, so it supersedes the new act. Further, in terms of the Section 11, in the absence of such arrangement, the minister can, by a gazette notification, make a treaty. I'm not going to say that because it is in favor of the Sri Lanka. Further, to above, that the provisions of the convention and act applies only to the members of the state or person who acted with the authorization, support of the state. So Section 3 of the Act and the Article 2 of the Convention. The preparators of LTTE who are responsible for the disappearances of thousands of soldiers cannot be attempted under this Act. So the other question is, the Act passed in 2018. The question is, can this Act apply to alleged war crimes in 2009, which is the retrospective effect, if this Act has a retrospective effect or not? To answer this question, we must look into the provisions of our Constitution. So Article 13(6) of our Constitution, Sri Lanka's Constitution of the Sri Lanka, says any act or omission which is a crime under the international law, though it was not an offense under the domestic law at the time of the commission, is punishable retrospectively. So the International Convention on the Protection of All Persons from Enforced Disappearance was adopted in December 1992. Sri Lanka ratified the convention in 2016 and absorbed into Sri Lanka's law in 2018. So it will affect retrospectively because of the provisions of the Article 13(6) of the Constitution. So not only that, not only just because of the constitutional provisions, at the trial and the appellate court of Bosnian War Crimes Chamber, WCC, in the case of prosecutor versus Simsik and another case, it was decided that the enforced disappearance is a crime under the Crime Against Humanity and comes within the ambit of international customary law. It is evident from the above two judgments, the offense enforced disappearance has a retrospective effect with the constitutional recognition given by the Article 16 as well as both of the cases. So, so there was a dispute among whether that the enforced disappearances falls within the ambit of the Crime Against Humanity, but later on, however, it was decided it is. So now it is the part of the customary law and it is accepted. So that is the other legislation. I'm not going to say in detail about the other legislation, just mention the name of the other legislation. The fourth one is the Assistance to and Protection of Victims of Crimes and Witness Act number 4, 2015, as amended by the number 27th of 2017. So that one also helped the international prosecution. It says it stipulates the provisions about how the witnesses are going to give evidences, such as the evidences from overseas via electronic methods. So I think that is in conclusion, the Sri Lanka domestic law is not specifically criminalize genocide, crime against humanity, but however, because of these 4 legislations, Sri Lanka is automatically absorb those kind of international illegal principles into Sri Lanka's legal system, and at the same time, Sri Lanka is going to support for international mechanism without knowing that those 4 legislations are exist in Sri Lanka's jurisdiction.
Thank you very much, Jairaj. So now we understood what we had to done. So what should be the next step? And so you have given an in-depth analysis, but we will do and further analysis, and we will advise respective individuals and organizations, especially the government of Sri Lanka and other groups about this matter. So now we have I think about the 20% of the questions came from one burning issue. What is the issue? And they are asking UK and Canada accepted panel of expert and OSL report as a gospel. Even death numbers are forged by pro-LTT groups. And similar to that is a similar questions came from, and about the Lord Nesby and Garch report. Actually, this question from one of the prominent lawyer from Mufali de Silva from United Kingdom, and he asking, should the UK hand over gas dispatchers to UNHRC in the wake of proposal to set up the special unit to collect? And he especially mentioned collect, consolidate, analyze, and preserve information and evidence in respect to Sri Lanka. So the question is for the panel, then I'm going to put that thing to Tamara. Tamara, and I think your mic is muted, so you can unmute. And how pro-LTT Tamil diaspora and managed include false death numbers to the report and the bring forward LTT version of the events. So that is the question came from.
Okay, I'm always coming back to the same thing. That is, the Human Rights Council and human rights itself, it has been politicized, and it is not about human rights. So on the part of the separatist diaspora, you can understand in a way that they will use for their own purposes and their own objectives within Sri Lanka to make as much publicity as possible outside and have them integrated into the report. Now, the question is that doesn't happen. The Office of the High Commissioner nor the Western governments do not take up systematically all those violations in any country. We know that there have been hundreds of thousands, but probably a million indirectly who died in the wars in Afghanistan, Iraq, and Libya. So we know that they don't take those issues systematically. So why did they take what the pro-LTT diaspora submitted? Because there was a political motivation, because they wanted to use it against Sri Lanka. One is to change the rules of the international order, which is undermining sovereignty. Two is to put pressure on Sri Lanka to achieve their geopolitical objectives in the region. So this is why you find these incorporated into the report. So it has nothing to do with Sri Lanka. That is why I think I'd like to go back again to this question that you have discussed earlier on, is yes, we need to change in Sri Lanka the laws and the extradition laws and so on. Yes, that's correct. But even if we do that, the countries that are hostile to Sri Lanka for other reasons, they will either invent figures or they will invent a situation like it happened in before they started the war on Vietnam. Every single war since the Second World War has been based on lies. So they would invent a story. Even if there wasn't a story, they would invent it. So the defense, the way Sri Lanka can defend itself, is to use the UN Charter. We have a rules-based order, which is the Charter, which is the only instrument today that is capable of defending and protecting the sovereignty of states. Because as I said, they're going to use it. They're going to invent something else. Yes, they hid the Gash reports. So you see, that is an example. There was information, and the UK has refused to share that information. Why? There is a reason for it. The Western countries, all those co-sponsors and sponsors, the core group, has embassies in Sri Lanka. The others don't. But they have embassies. They know exactly that there is no genocide here. They know that in Sri Lanka, there are more Tamils living in the south and the southern part of the country than in the north or the east. So they know it. So they know very well there is no genocide. So the objective is something else, and that something else is political. So that is why they accepted that information. So I want to come back to this again and again, that the resolutions of the Human Rights Council are political. They depend on the balance of forces at a particular time in the Human Rights Council or globally. So what Sri Lanka should be doing is to mobilize its natural allies in the United Nations, which is what we have failed to do. And we have failed to do because we have a policy now of, at least we have a policy non-alignment formally, but there are those within the government who are pushing for neutrality. Neutrality means we are going to be on our own. We are going to be isolated. We are not going to mobilize our non-aligned friends. But if we do mobilize our non-aligned friends, we can reverse the decision that has been adopted just now. And we have many opportunities to reverse them, because that's what the Human Rights Council resolution and that's what GA resolution is about. They are not legally binding. They are only recommendations. So we can have very well at the next session of the council, which is in September. The next session, there's going to be oral update from the High Commissioner, by the High Commissioner to the Human Rights Council. We can move a resolution. If we had the support of the majority, and if we go to our non-aligned friends, we have the majority. There are 35 members of the 47 unaligned in the Human Rights Council. So we can reverse it, but it has to do with Sri Lanka, the political will of Sri Lanka, and the courage to go out and mobilize our friends. But if we have people here saying, well, we shouldn't be confrontational. We should work with our friend, the United States, because they're going to impose sanctions on us. Then we are not going to be able to achieve this, because the moment we start negotiating with them, our friends will step back and they will abstain. This happened when I was in Geneva in 2012, when there were section of the government was negotiating, whereas I had clear indications, no negotiations. Because if the moment you start negotiating, the developing countries, they will say, okay, you're a sovereign state, you negotiate with the United States, we will not get involved. So we have to have a very clear policy and we can reverse the decision. We have several opportunities. We can reverse it in September at the 48th session when there's an oral update. We can prevent the budget being adopted at the 5th Committee in the General Assembly, also end of this year. Then we can have another opportunity. There'll be a written update March next year, the Human Rights Council session. We can reverse this resolution. We can simply have a resolution. No further consideration is necessary. And that will be the end of the story. Or if they have a resolution on the other side, a draft, we can defeat it if we have, and then the story is ended. There is no more. They'll have to come back again to another session to again mobilize support. But if we have established, we have another occasion is September 2022 is when there's going to be a comprehensive report. So that's another occasion we can prevent. We can get rid of the whole issue. We can take Sri Lanka out of the agenda. But for this, we need to mobilize the support of our friends. But we have to have the courage then to confront those who are confronting us, because we are not confronting them. They are confronting us. So we are only respecting the UN Charter. So we have the law on our side, and we will have the countries on our side, but we have to work together on the basis of common interest with those countries. So I want to say again and again that we can do all the technical, we can always change our laws, we can always say other figures, we didn't kill so many people, but then we are entering into negotiating on their terrain from a position of weakness. The moment we start negotiating bilaterally from a position of weakness, because we are fighting on their terrain, and their terrain are numbers. So we have to come back and say, bring them onto our terrain. And our terrain is the UN Charter, sovereignty. Build our coalition on the basis of common interests with the non-aligned countries. Then we can defeat that and we can reverse this resolution. So I want to underline that. I want to say that it is possible to change it, and we have the opportunity, because this is not a consensus resolution. The Human Rights Council or the General Assembly does not have the authority to set up a mechanism that has and giving it more authority than it has itself under the Charter, because this investigation mechanism is a prosecutorial function given to the Office of the High Commissioner. When the Human Rights Council becomes almost a tribunal, this is a violation of the UN Charter. So we have the law on our side. We have the UN Charter on our side. Let's use it.
Thank you very much, Tamara. And so next question to Professor Ghazel, and so you can unmute the mic. So a question is that how pro-LTT Tamil diaspora include into the UN system, and how they manage to include the wrong death numbers. Now what happened was that report, PO report, has been transformed into the OISL report, and now it has come to the end of the day, High Commissioner's report against Sri Lanka. So then the question is for you, what is the mechanism, what is the loophole they have utilized for LTT Tamil diaspora to manage to intrude into the UN system to bring the resolution in favor of them and against the Sri Lanka?
Well, first of all, we have to remind one thing very important. Sri Lanka is a decolonized state. I mean, it's a new state. But Sri Lanka Island was there forever from the beginning of the history. And when states were decolonized, the older colonies seized them as their hegemony parts. And in the political game, they always use the old partners. I mean, I'm unfortunate to say that, not to blame the Tamils, but it was always the same history. They used the minorities to control the majority in the colonized states. And after the decolonization, this becomes the subject of the problematic of positive peace in the countries. I mean, if you look at the Rwanda genocide, and if you limit it by time, like after the decolonization, 5 years or 10 years before and during the period, you can miss the real reason of it. There is the political hatred between the two societies, which was created by the colonizer country and Belgium. And what has happened after the decolonization of Sri Lanka? What has happened is the normal reaction of the Sinhalese people against the minority power and to change it. And then when we come to the position, the UK wants to use the problem. And there are 2 points important for that. If it is just for the human rights and the reconciliation, then the UK and the core group in their resolutions has they used the wording of the terrorist organization LTT. So there are 2 parts. LTT want to be accepted as a national liberation movement, by which they can still survive in the international arena, and they are to be the subject of international law, and they can still go on remedial suggestion. And this is also written in their webpage. Now we have to fight for what we could not manage by weapons, by guns. So they are inside the UN system with their aim to use the remedial suggestion theory. And to achieve this, they have to fabricate the false accusations, and mainly, and the aim of UK and the core group is different, because the aim of the core group and the UN and UK is to be still active in a decolonized state, former colony, in their politics. As Ms. Tamara mentioned, the former ambassadors, to use Sri Lanka as a, how can I say, military ally, and they have to force it against China. Let me read 3 things. I mean, what is the origin of the failed state is that killing of civilians through widespread shelling of hospitals, denial of humanitarian assistance. This is not true. It's always known by everybody. And when the UK and the core group use the OECD report, the evidences of the OECD report is subject to the emails that has been given inside the UN webpage. And all the false accusations came as evidences, but accepted truths. For example, the number of 40,000 people being killed is written from this information has been gotten from by a priest. I mean, how can a priest say that 40,000 people had been killed? What is his capacity? I mean, what is the reality? Because they did not go and ask as their obligation to fulfill the ICRC personnel in the ground. or the UN staff on the ground, because in the UN country team report, it is around 70,000 of people being killed in the last decade, in the last part of the war against terrorism. But they didn't had taken this number, and even it is an obligation, they did not take into consideration. There is an aim. So now two aims come together. One aim of LTT to be recognized as a national liberation movement, to be a subject of international law. And second, the aim of UK to be inside the politics of the Sri Lanka. I mean, it is not the problem of making positive peace for the future of Sri Lanka or for the reconciliation. I mean, I would like to return back the definition of war crime in the ICC Rome Statute. I mean, the ICC Rome Statute, it is said that as a systematic or widespread. What US and UK says that ICC cannot come to my soldiers, it is just one thing. I don't have a systematic approach of war crimes. They are individual crimes. And I can give the punishment by myself. If you accept ICC or universal jurisdiction, you accept something widespread and systematic, which comes to a responsibility of the state, and then you accept it as a fragile state, which then comes the responsibility to protect. I mean, these are the definitions, and to make a fragile state, they have to create that numbers or fabricated stories, and OECD report is accepted with the prestige of the United Nations as a real report. But unfortunately, what I say is that now Sri Lanka can ask High Commissioner and Interpol to ask a criminal investigation for OECD reporters. One, by not defining LTT as a terrorist organization, because in the mandate that had given to the Office of High Commissioner, it is written as combat terrorism. And second, by not implementing the UN Global Counter-Terrorism Strategy and giving impunity to international terrorism and international criminal financing of terrorism. So I do believe that the UK now defeated by itself, because sometimes the diplomats had a missing point, and then when they go on the OECD report, they thought that, hey, this is the game, and the game is over. And LTT thought that, hey, this is the game over, but it is not. Now, Sri Lanka government has so many things to ask from the international community, from the UK, and for example, any demand for universal jurisdiction includes the UN reporters, not to define LTT as a terrorist organization, or all the states, because when they made ethnic cleansing to the Sri Lanka Muslims, it's a crime against humanity. And no impunity and no amnesty can be achieved against a crime against humanity. And this is the decision of UN Security Council. So in fact, the OECD report is a criminal report against UN Security Council resolutions. In fact, what is done in the resolutions passed is a criminal resolution by not defining LTT as a terrorist organization, which had made ethnic cleansing to the Sri Lanka Muslims by not defining them as a terrorist organization. Resolution 30/1 and 40/1. In that sense, they are criminal resolutions giving impunity to international terrorism and their obligations arising from the binding decisions of the UN Security Council. It is a political game that the UK has been playing, and they are using the LTT, the terrorist organization, LTT members, and LTT members thinks that they are part of international community by not defining as a terrorist organization by the Human Rights Council resolutions and by the UN. This is the game, and LTT is to lose forever. If, as Ms. Tamara, former ambassador, said, if a Sri Lanka government prepared just a simple counter resolution with the wording using as terrorist organization LTT, giving reference to the UN Security Council resolutions. I don't want to enter which ones. Then the UK has an obligation to say yes to that resolution, and everything can change. And for a domestic jurisdiction against Sri Lanka in the future, I can say that no country will dare to open a court against Sri Lanka, because the game is based on the UN UN Human Rights Council resolutions are based on the OECD report, and OECD report based on false accusations and fabricated genocide claim. And if Sri Lanka asks for a criminal investigation for the reporters by the Interpol and their relation, and why they do not fulfill their obligation, why they change the mandate, then the game will be over for Sri Lanka. I do believe so.
Thank you very much, Dr. Gassel. But actually, there's a follow-up question for the Tamara. But actually, you have mentioned we had to be aligned with the non-aligned movement. So that is the a question came from an audience, and they're asking. So you are referring G77 plus China?
Well, yes, because two things. Within the Human Rights Council, the developing countries are represented within the framework of the non-aligned movement plus China, NAM plus China. In the General Assembly, they're represented within the framework of G77 plus China. So it depends on where we are, which forum that where Sri Lanka will be taking an initiative. But in any case, G77 includes the non-aligned movement. So it's a non-aligned movement. We are part of the non-aligned movement. It's different from G77. G77 is a group that works within the General Assembly only. The non-aligned movement is the much larger movement that was set up in post-Bandung, and with the objective of defending the interests of the newly independent states and preventing their return to foreign domination. So, and it's a very clear anti-colonial, anti-imperialist movement, which is based on the principles of peaceful coexistence, non-intervention, non-aggression, non-interference, sovereignty, international cooperation, mutual benefit, mutual interest. These are the principles on which the non-aligned movement is based. And so it's not neutral. It's not a neutral movement. It is there to defend the interests of the newly independent states, developing countries that are part of the non-aligned movement. They work from within in the Human Rights Council. That's the group that functions. The United States has been trying since the collapse of the socialist bloc to, in addition to undermining the UN itself and the Charter, they've also been trying to undermine the non-aligned movement, weakening and dividing them up, and exercising pressure on them. So, but Sri Lanka has been at the forefront of the foundation of the non-aligned movement. So we have to be, that's the framework within which we can build an alliance of for mutual interest to defend our collective interests. And so we can again come forward. We have done it before, and we have played a very crucial role within the non-aligned movement. We have been highly credible and have been respected even by China. And I have seen recently a video where Prime Minister Sirimao Bandaranaike went to China, and you had an incredible reception, very moving, with kilometers of Chinese there to receive the Prime Minister of Ceylon, which was a small country. It's a small island. And then you see this country like China giving such a warm welcome to us. So we have a role to play. We can do it, yes, and we can do it from within the non-aligned movement. That is in Geneva. In General Assembly in New York, we have to work with the G77 and China, plus China.
Thank you very much, Samara. And so we know that LTT, pro-LTT group, they were lobbying all front, especially in Canada, and all the politicians, and they are funding for their political campaign. And similar thing they are doing in the UK. And so we know that Boris Johnson, that the current Prime Minister's campaign, and that attached some group, especially a pro-LTT group, has given $2 million for to run the call center. And so those are allegations. So those are for the news reports. So, but according to the reply come from them, and they said so it is legal. So it is not the question. So now we have a question came from the audience. So I summarized this question altogether. Even though LTTE campaigned against Sri Lanka and anti-Sri Lankan move across the globe, and they were not succeed to bring the Tamil genocide case against Sri Lanka. And they couldn't come with the crime against humanity, and they couldn't come international investigation mechanism. And so even they failed at the International Criminal Court, and the UK government also refused to bring referendum to determine self-determination for the North and East. So in that case, so there's a question: had lost LTTE campaign forever in the UN system? That's after 46 session. So I will give first opportunity to answer this question to Professor Ghazel. So we go from there.
Yes, thank you very much. I mean, there is something interesting I have to mention first. LTT is acting as if it is the recognized national liberation movement. And when we come to the concept of national liberation movement, it's against the colonizer state. So they just try to use this concept in the sense of being against the principle of utipositatis. So what they say is that when Sri Lanka was decolonized, it must be divided into two, and this is the historical relations. But this is not the problem. This is not the legal background. Now, unfortunately, and very interestingly, LTTE is recognized as if it is a national liberation movement, even if it had made ethnic cleansing to the Sri Lanka Muslim by Muslim liberation movements. I mean, some Polisario Front people refuse to define LTT as a terrorist organization. I know this from my own experience. And I can say that very interestingly, they have got the political control, effective political control on Kashmir issue, on some political groups, and they have got effective political control on some Rohingya groups inside Europe. So the political roadmap of LTTE is to be recognized as a national liberation movement and to ask for remedial suggestion. And to manage this, the international system must prove that Sri Lanka is a failed state. And responsibility to protect must be implemented. And to achieve this, they have to sabotage the economy of Sri Lanka. If they do not organize a committee of a criminal investigation, an international criminal investigation for Sri Lanka, they want to sabotage the economy of Sri Lanka by an embargo from the European Union. Now, in my sense, this game is over. Why? First of all, I think I am one of the first person to say that the theory of LTT is wrong, because in the resolution 30/1, it has never asked an international committee of inquiry. It's promoting the system of justice with a new domestic body inside Sri Lanka. It's never been written. And in 40/1, they give total impunity, in fact, to LTT. But in this resolution, everything is based on paragraph 5. And they said that the Sri Lanka government, with the new body, doesn't give a mandate to the old war crimes. But everybody knows that. They have to create a reason to go on that. And they ask a third state to open a court by the evidences collected by the Human Rights Council. And it can be just with the reports targeted sanctions. So they cannot go on more on the failed state theory, which can go to the responsibility to protect and remedial suggestion. This is the important point. Why? the reporters of OSCE never and never define LTT as a terrorist organization. Because if they are once defined as a terrorist organization, they cannot get the monopoly of talking outside Sri Lanka. In fact, inside Sri Lanka, I can tell you, Tamils living in Europe cannot dare to say something against LTT. Their life is in danger. A Tamil, even in Sri Lanka, in Jaffna, still cannot dare so much to act against LTT because it has still have the power. The aim of the Human Rights Council is just one thing: the establishment of mandate to achieve positive peace in the countries, and to achieve positive peace after a long armed conflict, maybe 3 generations is needed. And for the 3 generations, if you define LTT as a non-state armed group, not a terrorist, you cannot achieve peace. So this is the game. And there is also one thing: LTT is still collecting money in Europe. And this is their job survival. This is for their existence. This is against the political will of the Tamils inside Sri Lanka, because they cannot say anything to LTT, because at the end it is defined. It is not defined as a terrorist organization by the UN, and this is why I have to say, mention always asking for a criminal investigation for the OSCE reporters by bypassing their mandate and defining LTT as a non-state armed group, defining the armed conflict as an internal war. LTT lost its game forever. And this is why also they choose a third state to open a domestic court. This is the formulation in paragraph 6 of the resolution. I do believe that this state is Malawi. And the existence of the future of the politics of LTT depends in the future court. If Malawi is to open against Sri Lanka government, they can change their mind. But this is the gossipness in Geneva, that Malawi is accepted, and this is why they are the new signatory in the core group. And how the program LTT is act from now on is that they will form a maybe new group. I don't know. Maybe Ms. Tamara knows much better than me, to collect evidences, and they will give much more information or false accusations, and they will be accepted as evidences, the reports of the UN High Commissioner as evidences to give criminalization of subject to some Sri Lanka officers. I think this is the game, but at the end, I do believe that LTT had lost its game. And on the other hand, the UK also lost its prestige. Because when we look at the prestige of the big countries, old colonizators, they had begun a game by Resolution 30/M. And they continued this game by 40/M. And thanks to Lord Nesby, that there are all false accusations, and UK and the core group of the European states or the other states cannot simply say that, sorry, we made a mistake, let's close the subject. They have to go on in a way that they have to protect their image to the Tamil diaspora, their citizens, and to the world. I can say something as an example why I say that Malawi is to open the court from the Rohingya issue. I was involved in the Rohingya issue. And when we talk about the Rohingya problem, especially members of Organization of Islamic Conference, they want to close the subject because the minds of the so-called Rohingya representatives in Europe was so huge. And these people act together with the LTT members. I don't know that. And I don't know their communication. And they're acting together. What they ask, same as the responsibility to protect, but their return must be guaranteed by the United Nations. That means without the consent of the government of Myanmar, the return must be established, and this is a military intervention. But it's Organization of Islamic Conference to cut the pressure on them. They make an arrangement, and Gambia opened a court. But in fact, it is the closer of the subject of Rohingya problem for the Islamic countries. And in my sense, if the gossip net is true, the opening of the court by Malawi means that in a way the UK is to close the court in their sense, because the UK can open a court as of today by itself. It doesn't need a resolution. They do believe that if they open a court in the UK, there will be the rule of law. But if it is opened in Malawi, there cannot be the rule of law in the sense of ICC, and the evidences will be accepted by the reports of the High Commissioner. So there are two parts. LTT is had lost its game inside the UN, and secondly, the game is played just for Malawi, and what can happen to Malawi is that Malawi should understand its own responsibilities. If it is to open a court against Sri Lanka, its obligations that are arising from the UN Security Council resolutions that had been similar countries for their resolutions, because the concept of the UN Security Council resolutions is important. So in my sense, LTT had lost forever, and the UK just sent the ball to Malawi to close the resolution in the near past. Thank you.
Thank you very much, Dr. Gasset. So my question, again, I will repeat. Had LTT lost its political game in the UN system? So I will pass the question to Tamara.
First of all, I would like to respond to Professor Mehmet. I don't have any privileged information on what the LTT is planning to do. They're not my best friends. And I have been also a victim as a Tamil. I have been a victim also of the LTT. You're right that the LTT has, even within Sri Lanka, it doesn't play the role that it played in the past. We all know that the LTT killed more Tamils than even the armed forces. And any Tamil that opposed their objective for a separate state was a target, primary target. So that's very clear. And the same is true in internationally. In Europe, they have targeted Tamils, any Tamil that was opposed to the so-called right to self-determination and a separate state. So yes, I think the LTT is a spent force in that sense. And the Western countries, the United States and their allies will use the LTT as long as it is possible to use them without losing much credibility themselves. And I think that they have not been able to get to convince the rest of the UN member states that the LTT is a liberation movement. And so that's what is reflected in the resolutions. But I want to point out that the resolution, the UN Human Rights Council, is only one of the fora that the US uses to exercise pressure on Sri Lanka. Their objective is, as we said, the control of the island, which is a strategically located island on the principal maritime route, trade route, and also the Silk Route. You have all the big powers who are interested in this region. From Sri Lanka, the US can easily target, on the one hand, the Middle East, Yemen, Iran, Pakistan, Russia, and China on the other side. So it is in a very, very important location, and that's why Sri Lanka is important to the United States. The US is using in the region for its strategy, advance its strategy against China, India, Australia, and Japan. India is our neighbor, and India played an important role also in the Human Rights Council against Sri Lanka. This time they abstained. When I was there in 2012, the Indians voted with the Americans. But let's not forget that particular resolution did not call for external intervention in a sense. It did not ask for the Office of the High Commissioner to act. It asked the government of Sri Lanka to report. So it did not involve foreign intervention. So India, it is understandable in a way that India wanted to put pressure on Sri Lanka and voted in favor. This time it didn't vote in favor of the resolution because the content of the resolution can have an impact, very serious impact on other countries, including India, precisely because it legitimizes coercive measures, it legitimizes the shifting the decision-making power from the Security Council to the GA and the Human Rights Council. It allows the use of expansive scope of universal jurisdiction to an area which is not acceptable even to India, and they would not want to have this used against India. So I think that was the reason they abstained. But that doesn't mean that that India is not exercising force on Sri Lanka. Recently, as you will have heard, the BJP, the leader of the BJP said they're going to open a BJP branch in Sri Lanka and in Nepal. And very soon afterwards, after he made that statement, the Sri Lanka BJP was launched inside the country. Let's not forget the BJP is a fascist party. It is a chauvinist Hinduist party, anti-Muslim and anti-Chinese. If they open a branch, because it is a branch, BJP is the Bharati, it's the Indian party, which they opened here, even though Sri Lanka has not taken a very strong stand against it, but they are here because they want to create chaos inside the country. They will continue to divide Sri Lanka on the basis of Tamil and Sinhalese. So that will be, and they will introduce this new, something new in the conflict in Sri Lanka. They will introduce religion, Hinduism, because so far the LTT has not used religion as an issue. They will try to do it. I'm not sure that it's going to work. And in addition to that, we have simultaneously within Sri Lanka extremist Islamic groups. We know what happened Easter, the Easter attack. We know that they are supported, the extremist Islamic groups are supported by the West and by the United States in particular. Then on the other hand, you have extremist groups on the side of the Buddhist extremists, like the Bodhu Bala Sena, also funded by the same people. And what they will try to do is they will divide the Sri Lankan people on ethnic lines and on religious lines. And this, what we are seeing here is probably only the beginning. We have moved from the phase of the LTT because it is a spent force. Both inside the country and probably outside the country, but they will create other issues inside, and I think that's what we should expect in the future. There is going to be greater problems within the country if we as Sri Lankans don't unite as Sri Lankans, and what I keep telling people in Sri Lanka is we have to watch out for that. We have to speak about the national interest, which is the common interest of all Sri Lankans, and the US strategy, the project that they have for Sri Lanka is not related to one or other particular group. They want to control all of the island. They want to take a full control of the island. MCC has to do with taking over all our resources, state lands. We have some 80% of Sri Lankan land is state land, and it's used by the Sri Lankan leased out to the farmers, and all this is the process of being privatized, and huge chunks of land are being privatized. The western coast is almost gone to the foreign corporations, and now it's the eastern coast. So whether you are Tamil or whether you're Sinhala, whether you're Muslim or Burghers, you are all going to be affected by the MCC. The MCC, even though they have withdrawn it, the project of the MCC is still going on. Then you have the SOFA. If SOFA, which is the Status of Forces Agreement, is signed, and that's still on the cards, we have to maintain the pressure that the Sri Lankan government does not sign it. it will allow for the US forces to come in to occupy all of Sri Lanka, not just the north or east or south, but all of the country, and they will move around. They'll be able to move around with their weapons, with their vehicles. They can come in without visas, and then they have the right to self-defense because under SOFA they have immunity. So if the people of Sri Lanka, somewhere in a village, there's a provocation, let's say the US, like they do in Korea or in South Korea or Japan, there's a provocation in a village somewhere by the US soldiers, and if there is a protest against the US presence there, they have the soldiers will have a right to self-defense, and they can shoot at the people. And if they shoot at the people and something happens to a Sri Lankan, we cannot take up the case against a US soldier in the Sri Lankan courts. So it's going to be, this is the project. It is on the cards. It's been on the cards for a while. Don't forget, we have signed AXA. Here in Sri Lanka, the Sri Lankan government does not want to speak about AXA. AXA has been signed. AXA is the agreement which permits the US forces to use our airports, use our ports, use our military installations for the US Pacific Command, which is in and out of Sri Lanka right now, and training the Sri Lankan army to in rescue missions, if the US the soldiers fall into the sea during the operations and they use them, and they're using our installations and our airports for what they call interoperability. So they facilitate. We are facilitating the movement of forces in the region to transport weapons and soldiers from the bases in Bahrain or in Germany, for instance, that has happened, into the US aircraft carriers that are in our region in the Indian Ocean. So they've been using the harbor in Trincomalee, because it's a deep sea profound harbor, and they can bring their aircraft carriers in there, and then they use the airport in Colombo to bring the stuff here and then move it across to their aircraft carriers either in the region or in Trincomalee. So that's already happening. So we are part of that.
Thank you very much for the great the information. So now we know the Western game plan. So what they are going to do. So we are very close to the finish our event. So we have over about 15 minutes. But however, I want to pose my last question to Jairaj. Had LTT lost its political game in the UN system?
Yes, Neville. I think in a way, they have lost their game within the, not only, I'm not saying about the UN system, but UNHRC especially. So when you're looking at the happenings, when you're looking at the current scenario, the reports of the High Commissioner as well as the resolution, both of the report and the resolution missed one of the main points they have been canvassing and they have been addressing over those years. That is the limited approach of the UNHRC mechanism to pursue the against the Sri Lankan government in the cornering the Sri Lanka to the last phase of war. The most important wordings is missing when you're looking at the resolution is that the atrocities committed by the Sri Lankan armed forces during the last phase of conflict. This has been the manifesto by the Human Rights Council, and finally, the Sri Lankan, the Human Rights Council come to a conclusion. It seems like to me that the Human Rights Council come to a conclusion that not just to investigating the last phase of crimes or atrocities committed by Sri Lankan armed forces is just not our mandate to in regard to the Sri Lanka. So they finally decided, coming to the census, that okay, there are other things we have to consider: the militarization of the Sri Lankan government, the COVID deaths, and so on, and the imminent infringement of the rights of the Sri Lankan citizen now and the future as well. So those are the things the Human Rights Commissioner, when you're looking at the Human Rights Commissioner's report, then the Human Rights Commissioner looking into the consideration. Even when you're looking at the resolution, it is going into a different direction. So it is for me that I understand in my perspective of looking at this, both of the sides of the resolution as well as the commissioner's report, it is showing that the Human Rights Commissioner is gradually slipping away the war crime investigation mechanism and the war crime investigation procedure set up by the Sri Lanka Human Rights Council. Okay, now the Human Rights Commissioner is saying, okay, if you are bringing the resolution, they're saying in the UK, okay, indirectly say in the UK, okay, now you are bringing the resolution and you get support from lots of countries when you're bringing down the resolution. Now you sort out your problems in your countries. Okay, you have your universal jurisdiction. There are 14 countries that has universal jurisdiction at now, and there are some other countries has local legislation that they can institute the war crimes or crime against humanity. So those countries, if they want to do it, then you can do it. What I can do is, this is what, if looking at the Human Rights Commissioner's mind, if I'm saying like this, okay, now what I can do is I will gather all the evidence for you. I have a setup, can set up a unit, then I will collect all the evidence because we have collected the evidence already. So I will gather all the evidence, and if you want some technical assistance, we can provide those assistance. So I will do that part only. So war crime allegations, investigations, or whatever the tribunals you're going to set up in your country. So that is not my game anymore. So that is what we can see from the Human Rights Commissioner's point of view when you're looking at her report. So also the resolution based on the Human Rights High Commissioner's report. So it is also says the same thing. Okay, we are going to look, but they forget to mention about what they're going to do. They just highlighted in the operative paragraph 6 that, okay, we are going to, the Human Rights Commission is going to set up this commission and set up this mechanism, and they collect evidence and so on. But they didn't specifically mention that what they're going to do afterwards. So just say, okay, support the international the mechanisms in the individual countries. So Human Rights Commissioner is not going to refer this to the Security Council. Human Rights Commissioner is not going to refer the Sri Lanka to the ICC. So it is up to the member countries to do it. So it is slipping away. Now the Human Rights Commissioner's concern is the current and future human rights violations of Sri Lanka. That is what the Sri Lankan government, the Human Rights Council, supposed to be doing. That is the major role, to analyze and support it, or criticize or uplift, advise the countries to uplift their human rights standards, not just about the atrocity committed during one of the periods of the time. So that, because it's been long time now, it's 10 years to 12 years has been passed. Now the commission also come to a sense that this is not going to happen. We can't do anything. So now we passing the ball back to the countries this resolution is bringing up. So you look after whatever you can do. So it is watered down. The atrocity committed by Sri Lanka during the wartime, it is not the major pavilion anymore. The Human Rights Council is not the major partner for this anymore. But the Sri Lanka should not take, in my point of view, Sri Lanka should not take this easily, because universal jurisdiction is a powerful tool. They has been tested in several countries, and especially in UK. It is, and Dr. Mehemet also mentioned that the Malawi should be the next country to bringing up a court case against Sri Lanka. But there is a possibility that there is, with the support of the Human Rights Commissioner, the evidence gathering mechanism is going to cater some kind of a support for if someone is going to set up a commission or set up an international investigation mechanism or international court against Sri Lanka. So there is a possibility then the Sri Lankan government should mobilize to defend and address the issues, as well as Sri Lankan government should, as Tamara clearly mentioned, the Sri Lankan government should have a clear policy to address the aftermath of the resolution. Either we stand for the resolution, either are we going to cooperate with the resolution, or either we stand to the standpoint where we have standed last since the 2009. I think the first started 2019. We clearly stated that we are not going to cooperate with the international mechanism. Then the Sri Lankan government stated afterwards that we are not going into the resolution of co-sponsorship anymore. Now we ask for a full withdrawal. So Sri Lankan government should stand its own position rather than going into the co-sponsorship consensus or any kind of a betrayal in the point of Sri Lankan people's citizens' view. So if it is now slipping away from the UNHRC, as you stated clearly, it is the time that the Sri Lankan government should think upliftment of their own standards. So if there are any other issues of the human rights issues in Sri Lanka, Sri Lanka can easily sort out their problems within the Sri Lankan community. As Tamara finally stated, that it is up to the Sri Lankan government to protect the Sri Lankan citizen, whether you are a Tamil, whether you are a Muslim, whether you are a Sinhalese. It is all Sri Lankan citizens. So it is the duty of the Sri Lankan government. We all accept. We don't have to tell the Human Rights Council or Human Rights Commissioner to say that you should protect your citizens' rights. It is our right. All the people voted for a government. 6.9 million people vote for the Sri Lankan current administration. So it is the expectation of all Sri Lankan citizens that Sri Lanka would protect all citizens' rights. So it is a simple thing. Now that is what the Sri Lankan government should focus mainly. Apart from the protections and apart from the defenses, Sri Lanka has to adhere apart from that.
Thank you very much, Jairaj. And so we come to the end of the webinar, and so we have discussed wide range of topics, how we can use some UN mechanism to protect the sovereignty, breach the sovereignty of Sri Lanka. In addition to that, we have discussed about the PBI program budget information for the UN. That is also possibility aspects we can look at it. And then in addition to that, other sovereignty clauses also we have extensively analyzed, and for the legal mechanism also what we can implement to protect our citizen. Regardless of Tamils or Muslims or Sinhalese, government has a responsibility to act very quickly to protect all the citizens. Because we have rehabilitated 13,000 LTT card, we cannot open any single file against them, and we cannot allow High Commissioner to come and collect the evidence using these individuals, and it will damage the reconciliation and I think harm. So this is our question. Then the second question I posed to the panel, and had LTT lost its political game in the UN system, all the three panelists unanimously agreed that there is no any political game within the UNHRC and for the UN system. So now we have to think about the other global aspects and geopolitical avenue, how the Western powers is going to play against Sri Lanka, how we can mitigate the issue. And Tamara and panelists clearly mentioned that we have to stand on the non-aligned strategy. So that is the best strategy I can say for right now. Thank you very much, all the participants who are joining with us for all over the world. I am very much thankful to you, Tamara Kurunayakam, our former ambassador to the Geneva, United Nations. Thank you very much for joining with your busy time to further this very important webinar. And Professor Gazel from Switzerland, you joined with us. Thank you very much for your participation and taking time off from your busy schedule. And also Jairaj Palliyawadana, convener of the London Initiative. Thank you very much for your contribution and very inside legal opinion about the subject matter. Thank you very much. And also we have a Munasinghe station in Canada. I believe that she is stationed in Ottawa area. So maybe all links. Thank you very much for your technical support and collaboration with the group. Thank you very much, everybody. Then finally, I thank you, everybody, attendees involved, participate for the event. Thank you very much. And so I officially concluded the event. Thank you.
Thank you. Thank you, Tamara.
Thank you. Thank you very much.
Thank you, Raj.
Thank you, Tamara.
Yeah.